Welcome to meeting number 93 of the House of Commons Standing Committee on the Status of Women. S205, pursuant to the order of reference of Wednesday, November 1st, 2023, the committee will resume consideration of Bill S205, an act to amend the criminal code and to make consequential amendments to another act. So we are at the meeting of December 4th, the committee adopted the following Clause 1 as amended by G1, G2, Clause 4, Clause 5, Clause 9, and Clause 10. At the meeting of December 11, the committee adopted Amendment G3, G4 pertaining to Clause 2. At the meeting of January 30th, the committee adopted Clause 2 as amended by G5, NDP2, G6, and G7. Clause 3 as amended by G8, Clause 6 as amended by G9, G10, G13. It's already moved by Lisa. On January 30th, we are resuming debate on G13.
I just wanted to jump in on this to remind committee members about G13. It's really just another amendment to make the legislation coherent with things we've already agreed upon in relation to G3. I don't know if the officials have anything further to add, but that's what that's about.
There's no speaker on the list. Oh, there is. Okay. Karen?
Hi, just making it very simple. I believe that we did look at G13, discussed some of the changes, and I believe at this time we recognize that it is just in cooperation with the rest of the bill, so it looks good to us.
Okay, so everyone is clear. Then shall G13 carry as amended? Yes. Okay, everyone's in favor, no opposed, so G13 carried. Shall Clause 8 carry as amended? Yes. Okay. So Clause 8 carry as amended. New Clause 10.1 G14. We are resuming debate. Okay, Lisa?
Thank you, Chair. I'm happy to move this amendment. This is a coordinating amendment with Bill C-21, which is also in the process of being passed through Parliament. So this is a technical coordinating amendment to ensure that this bill will align with other bills in Parliament that we're studying.
So all in agreement? And okay, Michelle?
Thank you. Just for the record, obviously, we've been pretty candid about where we sit with BC21, just in terms of it going towards law-abiding hunters, sport shooters. So, you know, I think that we just want that on the record. And I also just want to say to my colleagues, you know, there was sort of an abrupt or move to adjourn last meeting. And the reason is because it's really important that I hear from the senator when we're dealing with this and that he's okay with this. This is his bill. And so for me, it is making sure that I'm listening and I have all of the right information. So it's not a partisan hack or something like that. And I just want that on the record, that this Senator Boisonnov put this bill forward with so much heart, and he's retiring, and his daughter was murdered, as we've said into the record many times. And I just want that. I know I've talked with my colleague from the NDP about this, and we know we want to get this to the House and we want to get it correct, but I just wanted that for the record, that was that issue. It was just trying to coordinate, and that's why we had to suspend, and just making sure that he's okay with this. That's really what we're here to do, is be his vessel to make sure that his daughter's honor is in the right tact. Just wanted that on the record. Thank you.
So no. So okay. Shall G14 carried? Okay. So everyone is in favor. No opposed. G14 carried as amended. Shall Clause 11 carry as
G14 is just carried.
Yeah.
Just carried.
Shall G14 carried? Yes, it is carried. Shall clause 11 carry?
No. Chair, we are opposed to clause 11 because it would repeal changes that we saw in Bill C-233 that this committee studied, Kira's law. It would mean that the coordinating amendments to the clause would not apply. So that is why we would vote down this amendment, or this clause.
Okay. Michelle?
Just curious on the analysts' opinions on this as well, and on how it would impact 233.
And please.
Thank you for the question. So originally, as was explained by the member, that's what would happen, but you'll remember that Clause 1.2 of Bill S-205 regarding electronic monitoring has been removed, and so S-205 no longer deals with the electronic monitoring in the bail context. It's still in the peace bond. And so at this point, it's not necessary because we're not addressing the same things anymore. So
just to follow up on that, I think this was one of the real issues of contention for us with conservatives, as we wanted that electronic bracelet, just so we wouldn't be supporting this. We can do a recorded division, but I think for us sitting here, the real issue is that period of time, that vulnerable time of bail is often statistically when we know the victim is most vulnerable. So that's why we didn't support the removal of that. We obviously lost the vote, but we would want that in, but I just wanted that on the record as well.
Officials, you want to answer that?
it may be helpful to know that it is in there in the context of domestic violence due to the approach taken in C-233. So that one explicitly requires consideration of the use of electronic monitoring as a bail condition for a certain narrow set of offenses. And that would include situations of intimate partner violence. So that may provide you with some comfort that that is in there in relation to 233.
So what you're saying, if I understand correctly, through you, Chair, this is where I miss my colleague, Miss Lewis, who is a lawyer, where she's so savvy in these things. You're saying that because it's covered in Bill C-233, you don't need it in 205?
Yeah, so C-233 maintains and it can be used even if it's not explicitly in a peace bond. There is a broader option for this still to be used in any context. But because C-233, sorry, that's in the peace bond context. In the bond context, C-233 says explicitly, in terms of violence against a person used, threatened, or attempted, including against accused's intimate partner. So that aspect that you were concerned about is covered by that bill, which is already...
I guess so my question is, so why wouldn't we want it in 205 if it's already there?
Why would we?
Why wouldn't we?
So this, right now, so that decision already was made with clause 1.2.
Exactly my point. So I think that's what I'm saying, unless I'm getting confused, which is possible, but I'm saying if it's already under one area and it's in 233, and then we lost the vote to lose it down in 1 and 2, but it's already there, like what would be the benefit of removing it, is I guess what I'm saying.
Would you like me to speak to the, I could speak to the effect of the G1 motion that was voted on previously, if that's helpful to the committee. So the effect of the G1 motion was that electronic monitoring would not be explicitly listed as a bail condition that a court could impose for all offenses. So that's what Bill S-205 had proposed, that electronic monitoring be added so that it could be imposed for all offenses. Currently, the conditions listed in subsection 515.4 of the Criminal Code are sort of standard conditions that are routinely imposed more broadly applicable to the different types of charges that come before the court. For example, report to a police officer, remain within a certain territorial jurisdiction, not to contact the victim or go to a certain area of the city. These are sort of standard conditions that are routinely imposed, and that's why they fall under the standard bail conditions list. Any condition that is added to the standard list does have the potential to become more routinely imposed, simply because it's easy to check off once it's on a list. And while in many cases it could be considered a necessary condition, it could also be routinely imposed despite that it might not be reasonable or necessary. But as mentioned previously, even if it's removed from that list, so the fact that it's not included in this bill would still allow it to be imposed where appropriate, because a judge has this residual power to impose any condition that's reasonable or necessary. But also judges would be required to consider electronic monitoring as a result of the changes made in Bill C-2233 in cases of domestic violence.
Thank you. Anna?
And I'm a little confused, so I did miss a few meetings because I was on another committee at the time. So can you explain to me why we need to remove this?
We don't. We lost the vote.
I understand that, but in Kira's law, it wasn't his ex-wife. It was the fact that the husband killed himself and the child, who complained to the mother on numerous occasions and the judge. So how do we protect other victims from this situation happening again? If like, I'm a little confused, and maybe you can clarify that for me.
Just in terms of the rationale for this particular motion, or voting down this particular motion, is that there's no coordination that's needed anymore with Bill C-233, because the provision that would have needed to be coordinated has been removed from a previous motion in this bill, so there's no need to coordinate the two bills anymore.
Leah?
So my understanding is that protection is already covered in Kira's law, and it's just repetitive. So they would still be protected. It's just you don't have to repeat it in other, like every legislation, because they already have that protect. Am I wrong? Is that wrong?
Mark?
Is that wrong? Is that incorrect? What I'm understanding?
So maybe officials can answer Leah first and then Mark.
Okay. Well, no, okay, just on the point, I just want to, like, my understanding on C-33, the judge has the discretion to put the ankle bracelet. So that's already in place today, okay? So that's in place. My understanding with G1 motion that we had with Anna and Michelle, what you're debating is the amendment that was removed was that it would be automatically put regardless of judge's judgment. So which would then, we heard, that would penalize Indigenous women and would penalize marginalized women. Because it was automatic. The judge had no, so the way C-205 was written, it was like explicit ankle bracelet on automatically. So there wasn't that judgment that the judge could decide, and because the victims will be protected. So I just want to, I don't know if I'm not a lawyer like Michelle said, but that aspect I thought was because of the C-205 would have penalized marginalized women and Indigenous women. So now the judge has the obligation and discretion in C-33 not to marginalize and penalize Indigenous women, but make sure that if needed, the ankle bracelet would be put. So
Leah?
did that explain?
Leah?
My understanding is well in that, but the other issue is that, like, in certain parts of the country, we don't have, like, proper cell service and stuff like that. So if you make it mandatory and the person's in a place where it's not even going to work, like, it's just, but it's it's useless. So like, it's expensive, and it gives people a false sense of security. And the people that, are responsible for paying it. So that was some of the arguments that were brought up. But I think, in fairness, I mean, like, I understand what the intention is, but, like, it won't even work in a lot of places in Canada. So you have a whole bunch of people with bracelets for what? So people think they're safe, but they don't have cell service, and they can't, like, that's a problem too, right?
Anna and then Michelle.
Okay, so here's, I mean, if Bill C-233 was in effect, I think Kira would still be alive today. But my point is, and maybe I don't understand this bracelet because I'm not a criminal, but when a criminal gets this bracelet administered, is there not a length, like, is there not restrictions that he can only go a certain distance and he has to, like, he can't just travel out of the country? Do you know what I'm saying? Like, so wouldn't that be picked up if he's out of an area?
Official, please.
So each province has different uses of the electronic bracelet, so it really depends on the jurisdiction, how, I guess, how efficient the technology is. It's hard to say right now if that technology would permit what you're proposing. I think it probably would in some places. I just don't know how broadly it's being used for that purpose. I know that from what I read from some reports in Quebec, it can be used for certain addresses. So as soon as an accused goes within a certain radius of a certain address, it can sort of send an alert.
Can I respond to that, Madam Chair?
Sure. Anna, go
Oh,
ahead.
okay. So, and the reason I bring this up is
Je pose la question parce que j'ai déjà été directrice de succursale et
I'm having issues. Okay. Okay. So in my past life, I was a branch manager, and someone was released on bail with a bracelet, and he was not allowed to come in in a certain distance of any banks, not just the branch I was at, but any branch. Guess what? It didn't work. However, from what I was told from the police, and this happened a long time ago, there was a method in which he could still be wearing it, but not have it correspond. I don't know how that works. I'm not a criminal. So that's what scares me. It scares me that we're still not putting the victims first, and I'm just wondering if this is going to, I mean, we need to pass Bill C-205. Yes, we need to pass it, but I just want to make sure that all the protections for the victims are in place so that this doesn't happen again, that it happened to the senator's daughter. That's my worry.
Thank you, Anna. Michelle?
I think one of the big concerns around this one, why it was so contentious, was this was kind of the foundation, I think, of the bill for the senator, in that the victim would have access to see where their attacker was. And so I guess my question to you, again, through the legal world, is would that happen? The other thing is what I can't reconcile here is if it's covered in 233, why wouldn't it just be put in 205? I don't understand why you wouldn't make that for consistency. So two questions there. Number one, does the victim still be able to monitor, have that choice to monitor? And if this is removed, and number two, if it's already in 233, wouldn't it be more consistent to keep it in 205? And I apologize that you guys went to legal school and I did not.
Officials, please.
Thanks for the question. So just to clarify, Bill S-205 would not be taking it out of what the changes. No.
Okay.
No. Bill C-233 came into force, so it received royal assent April 27th, 2023, came into force 30 days after that, so in end of May 2023. And it requires in every case where there's been a victim of domestic violence, for violence from which a person was used, threatened, or attempted, including violence against an intimate partner, the judge must consider imposing an electronic monitoring bracelet in all of those cases. That is not going to change by this bill. That remains as part of the law.
Okay. So what about I guess the back to that other question then, it's still the judge's discretion of whether or not this happens. So then we come back to judge training, et cetera, which is a whole other can of worms outside of this bill. But I guess that the next question is, what was critical again in this was that the victim was able, if I'm understanding correctly with Kira's Law 233, the victim doesn't get to monitor the electronic bracelet, just the police officials and law enforcement. But with this 205, that was written into the bill. Is that correct? It's not? Okay. Then I stand corrected. Okay, thank you.
So no more intervention, and then can we, what is this? Clause 11 carry? No. Oh, okay. So as amended, can you show hands who is in favor of that?
Favor of clause 11?
Yeah. Any opposed, or everyone is in favor?
Close the clause 11, we're all
Okay.
opposed.
So opposed, yeah, okay, so clause 11, carry amended.
It's negative.
Oh, so we dropped it. Sorry, guys, clause 11 dropped from this, okay. So shall clause 12 carry as amended?
No, just carry. Shall it carry?
Just carry. Just the first shall, clause 12 carry.
Okay. Shall the title carry as amended? Okay.
It's not amended.
No, just
Shall
shall the title carry.
Shall the bill as amended carry? Yes. Okay. Shall the chair report the bill as amended to the House? Yes. Thank you. All done. Thank you, guys. Thank you. And thank you, officials, too, for your excellent explanation.
So do you want to adjourn?
Of the committee to adjourn?
We're all done?
Yeah.
We don't have anything else to do?
So that is all on agenda. So is the will of the committee adjourned?
Want to stay for 2 hours?
Committee adjourned.
Thank you.